Can you hear me?
Yes, I can.
On the live thing on Facebook, I can see Paikat's face only. Can you hear me? Okay, I can see mine. Yes, I can. On the live thing on Facebook, I can see Paikat's face only. Yeah, I can.
Very good afternoon to everybody here. Welcome to our MICCI webinar series on COVID-19 legal considerations. We are very fortunate today to have with us two very distinguished panelists, Mr. Tay Peng Chai and Mr. Chiu Pai Ket, to share with us their thoughts on the legal implications of the pandemic and what are the options for businesses. Our moderator for today's session is Mr. Azrani Rustam, MICCI Vice President. He's also the Director, Corporate Affairs and Communications of Japan Tobacco International. Before I hand over to Mr. Azrani, please allow me to do some housekeeping rules. Each speaker will be given 10 minutes to speak. And I'll be also acting as the timekeeper. We will flash the 2 minutes when the time balance is left with 2 minutes, yeah? So, and also participants are encouraged to post your questions online through the Facebook Messenger, and we will pick up your questions as and when if we can. And yeah, please post it maybe from now onwards so that we can be ready in advance. So Mr. Azrani, can I now hand over to you?
To this webinar series organized by the Malaysian International Chamber of Commerce and Industry. I'm very pleased to be here, and I think it's we want to discuss a pretty important topic, pretty heavy one as well, but it's a topic that is important to be discussed nonetheless, given that there's so many questions around it, implications, the ramifications, as well as what would happen moving forward. Again, this is a very wide topic. It's an issue that is, as we know, impacting everybody around the world. But we want to narrow it down to really in terms of looking at the impact to the businesses. And I think we all are well aware of the implications of COVID-19 already. All of us are impacted in one way or another in our daily lives, in our private lives, in our public areas as well. And there are definitely issues around that. But today, we want to try to understand further what are the issues, in particular the legal issues surrounding COVID-19, and trying to uncover as well a bit some of the uncertainties that everybody has faced, and to also look at some of the solutions that may be available to us as businesses, and some of it maybe us as individuals as well, and also then to look forward to what may be the legal landscape for all of us as we weather this particular storm. So I have with us two very distinguished panelists, people who might know pretty well, and who are distinguished in their professions. Obviously, they're lawyers. So, and therefore, it's good to be here. So I have the unenviable task of having to moderate a session with two distinguished lawyers. So let's see how we'll be able to deal with that. But I think I know we have firstly Mr. Chu Pai Kiat, who is the partner for the firm Raja Darrell and Low. Pai Kiat is well known to many. He's been practicing corporate and commercial law in various areas, including mergers and acquisitions, conveyancing, etc. Intellectual property, where he has written quite a number of books as well on it. So he's well known out there and amongst us. Mr. Teh Beng Chai as well. People will definitely know him. He's the managing partner for the firm Teh and Partners. Beng Chai actually, separates his time between doing corporate and commercial legal practice in both Malaysia and Singapore, and that brings a very interesting perspective because Singapore as a jurisdiction has been pretty advanced in terms of setting the legal certainty around and having an act. So we'll be discussing a bit on that. And Mr. Teh is also the founding partner of Singapore-based Bird and Bird ATMD LLP, and this will be of interest to us. So I would like to start by again highlighting a few things. Firstly, on MICCI, just a very brief one. Many of you are following this, so you will know. I won't go into too much details. Many of you may be just seeing this for the first time. So MICCI, the Malaysian International Chamber of Commerce Industry, is the longest established and leading international business chamber. So we currently have about 1,000 members, and it's unique in very many ways because we have both the multinationals on one hand and also the SME on the other, and smaller entities. And this is important, and we have several chambers around the country as well, who are associated chambers, and we pride ourselves in actually being the chamber that with a focus of promoting and facilitating and advancing, more importantly, free enterprise, international trade, commerce, and investments in Malaysia. So that's basically very much our focus, in line with many other chamber operations around the country and around the world. And even so, more so, over this couple of months and the period, we've had to be much more vocal and much more involved in trying to, in line with the focus things that we are doing, to push and promote the views, in particular, of the business community. Some of which are very relevant, many of which may be even controversial, but it's important nonetheless to highlight out there. And I think it comes to the point about the COVID situation, where we all started to see this In some cases, some people said that, we saw this pretty much from afar, that things were going to, were a concern. So when we started the year, it was very much a concern, and how it would impact, the economies, how it impact demand, output, etc. Then came March, and on the 18th of March, the movement control order, the first iteration of that, came into being, and then it wouldn't be a understatement to say that more or less all hell broke loose. And for businesses, particularly in our country, it was two things. That firstly, it was an unprecedented situation where we went into a partial lockdown. We were not a full lockdown, but it was a partial lockdown. The second thing that happened was the uncertainties around that. And I think the first thing that happened to businesses at that particular point in time was the uncertainty of two things. One was whether they could operate, depending on whether you are part of services or you're part of manufacturing. Secondly, was whether you will be able to move easily, and the freedom of movement were curtailed in many ways, so that impacted business as well. And if you're looking at the whole spectrum of the supply chain, from goods coming in to going to the retailer and to the consumer, at each point in time and each point of that chain, there were issues, and there were issues faced. And it raised some other issues, in particular, who was able to operate, when, and then also, what powers were being used to very much curtail operations. And of course, in the good name of trying to address the COVID situation, certainly that is everybody's objective, and as businesses we recognize that. But certainly over that period after the 18th of March, it was a disruption, and that disruption cost businesses money, it cost time, it cost quite a number of things. I was very much, I saw today in a report that we're still many businesses are trying to assess the impact of what happened. But we went on through this MCO and then CMCO, and then now we have this recovery movement control order over several weeks. But I'm attracted to this report that apparently came out from the Retail Group Malaysia, that they estimated about 209,000 stores. That's accounting for about 61% of total retail outlets in the country, and 63.3% of total retail sales were closed during the first 6 weeks of the movement control order. And during that 6 weeks, retailers, in particular the non-essential stores, incurred about 14.31 billion in operating costs, and that's not including the additional about 6 billion in staff costs, salaries, wages, etc. Now, what is more important, so that's the loss during the period, and this is what we're going to be covering, some of these, those losses and issues that impacted. What is more interesting is they are estimating that moving forward, out of that total number, 40% of businesses in the retail sector will not be surviving this. They will be permanently closed. And you add that on top of that, the other things that were mentioned, in particular what the Prime Minister said over in the speech with regards to the Penjana program, where he mentioned up to 800,000, close to 1 million people would be unemployed, and businesses, the economy is going to be impacted moving forward. I think it's very much worrying how this will be, we'll weather this, and then it comes to the point of, as we had gone through it, what could have been, obviously better, and maybe we don't want to look too much to the back to history, but at the same time, we do take some learning from there. What really happens then moving forward? And those uncertainties that have gone through, we now are going to be relaxing some of the restrictions. We're now fully operational, yet there are question marks. If things were to deteriorate again, if it spikes further, what will be the reaction from the authorities? and how will they act on those those concerns. That not necessarily been answered fully. Certainly, the Prime Minister mentioned that they would be, looking at localized control movement orders or enhanced on a localized basis. But on a widespread basis, how would this be dealt with? And I think for businesses, what we want to try to avoid and ensure this is avoided, that we don't go back to a situation where we were more or less in enforced, business lockdown, and depending on which sectors you were in, and that would have long-term implications. So people are talking about the new normal. We recognize that this is going to be a new normal. How is this new normal going to be facilitated, in particular by the law, and how we're going to move forward on that? I think that remains all to be seen. That sets the seed. Yeah, so we all know, I wouldn't go into too much detail of that, of how we as businesses, in one way or another, in our own individual ways, have been impacted. But I think I want to start off really before we go further into discussion, and I do hope we have a very participative, crowd out there, because there's definitely a lot of questions around this, and there's been quite a bit written about this as well. I want to go maybe taking a step back and maybe to put into proper context of these control orders that's been been laid out, and the issues around that, and then before we go forward. So with that, I'd like to invite Paikat, whom I'll just remind Paikat that you have about 10 minutes before we go into the other parts. So over to you.
Thank you, Azrani. Hope my voice, audio, visual are okay to all participating. Thank you to MICCI for this opportunity to share my thoughts on the legal issues. And I will take these 10 minutes to sort of paint the legal landscape on the backdrop of what Azrani has powerfully shared about the real pain we're going through. So share the legal landscape on existing law, both from private versus government sector, and in terms of government being the decision maker, and then also between private sector and private sector. Just 10 minutes to give you the legal landscape, and then, and as I said, it's on the existing law, and then I'll hand over to Mr. Tay for a even more interesting discussion on what could be the legal landscape being changed going forward, in particular with respect to new legislation that will come upon us. So regarding the legal landscape, I'm going to break it into two parts. One is between us as the private sector with the government in terms of what they have done. And for that, I guess the three questions that I want to ask ourselves and articulate a tentative response to these questions in terms of what the government has done during this MCO period. So probably we're asking ourselves, was everything done? The first question, was everything done in a legally proper manner? That could be one question. The second question would be, was everything done in a reasonable and coordinated manner? Okay. And the third question flowing from that would be this: if the answer is no to either of the above questions, I guess the question we ask is, what remedies do I have against the public sector, the government, because they were the decision makers, they were the implementers of those orders? What remedies do I have if I suffered a loss, assuming that things wasn't done in a legal manner or a reasonable manner? Okay, so to give you the legal landscape on this, all the actions done by the government emanated from a particular statute, which I call PCDA for short, okay? But it stands for Prevention and Control of Infectious Diseases Act 1988, numerically called Act 342, Prevention and Control of Infectious Diseases Act. So I call it PCDA for short. And this would be a health act, an act for the protection of public health and safety. And for one, I want to put a record, surely we must all agree, health and safety comes first. Okay? And whatever we do is for that purpose. Making money is secondary when we talk about public health and safety. I know there's a great argument between life and livelihood and how they are connected. And you know, this question is raging in countries like Brazil and other places as well. But I'll just rest on that, yeah? And so this act, PCIDA, is meant to do that. When there is an infectious disease, in particular a widespread or dangerous infectious disease, the Minister of Health, MOH, and his number one executive person, okay, carrying out the wishes of the act or the relevant health legislation, the Director General, okay, the DG, have powers to ensure that this infectious disease is controlled, and they have powers to issue orders and regulations. And this is what they have done. In fact, the latest came out yesterday on the latest MCO order based on the RMCO, the Recovery MCO order. And so under this act, there's wide powers. There's wide powers to the MOH and as the minister, as well as delegated to the DG to do anything, almost, I mean, I said that anything within the confines of the act, of course, but the anything could be preventing mobility, closing down premises, forcing tests to be done, etc. All these are available under the PCIDA. And in Section 5 of the PCIDA, it is also stated that the minister can enlist the help of other government departments and agencies. I'll just read that Section 5 for you to get a feel of it. Police, it just goes straight to say this in Section 5 of the PCIDA. Police, customs, and immigration officers and officers from other governmental departments and agencies shall render such assistance as any authorized officer may request to exercise powers vested by the Act. And together with that, Section 4, talking now about liability, Section 4 of the PCIDA says that any officer, including those enlisted officers from other government agencies and departments, any officer acting for the purposes of the Act are immune from personal liability when they perform their function. Now, I don't have to justify why those sections are there. Enough said that they are there. And so although we have seen a mix and match and sometimes confusing array of different persons, different ministers even, MKN, and then the MICCI, and then the Defense Ministry, all having a say in what they do, one can only assume that everything has been legally and properly done using this act, the PCIDA, in order to empower these other agencies to do what they did. Now, whether we have sight of the internal memos and how was this delegation done, yet to be seen. Okay, that's something to be seen if this ever became a legal issue. Yeah. So I would say that the law is there to allow such other agencies to act on this, and it has been acted upon. Now, as Azrani mentioned, we can always say, you know, it's called a 2020 hindsight. Hindsight is always 2020, and we can always say, could things have been done better? And we will always say yes. And I particularly like what Azrani mentioned. Okay, even if we didn't get things done properly in the best manner possible, going forward, if we have a spike coming back and we go back to MCO or even EMCO, let's make sure we learn from what happened to do things better. So now I'll come to the first question. If something wasn't done in a legally proper manner, what remedies do we have? Now, I must say that we are going towards the tail end of the MCO, right? And so whatever happened already. We are now taking steps to get back to new normal, yes, but almost a semblance of normal working life, normal operational life. So the MCO and the trouble it caused us is almost over, okay? But if you want to look back to what happened in the MCO and what loss I suffered because things weren't done in a legally proper manner, I have that question, how do we prove it? Okay, I already mentioned there's this Mother Act, the PCIDA, that seems to give wide powers to do all that needs to be done. Okay, were things done in a reasonable and coordinated manner? Definitely will say no in some respects. Okay, SOPs were confusing. First, I could do this, then I couldn't do this. I had to undo what I did, or I had to do what I thought I couldn't do, etc. All this happened, of course. Even in the law firm like ours, we were struggling. Do we take temperature outside the door or inside the door? When people come to our office, all these SOPs were there. And there were special SOPs just for lawyers. I don't know why we were victimized in that sense, in a comical manner. So even if we can prove, the point I'm making here in terms of remedies, even if you can prove that something wasn't legally done properly, there is a difficult question on what can you get out of it from the government. And I must here say straight away, if an order or an SOP wasn't properly conceptualized and implemented, okay, yes, you can get a court order to say the SOP is ultra virus, or rather beyond the law, and should be declared null and void. You can always get that kind of court order. But like I said, it may be water under the bridge because we are now passing the MCO, right? But even if you wanted to get that court order, you can get that if the court is with you, that this order is not properly done under the law in terms of administrative law. So that's always there. But getting damages, you see what I mean now, getting financial compensation from the government because this order wasn't properly either implemented or issued is, put it bluntly, a tall order. Okay, because the courts have been very slow. In fact, I can't find cases in Malaysia. The only ones where they've ordered legal remedy in terms of financial compensation were based on decisions done where the underlying act, such as the Industrial Relations Act, when you have unfair dismissal of employees, the underlying act says you must pay compensation anyway. So you challenge the order of the Industrial Tribunal, the chairman of the Industrial Tribunal, and then you get the payment made. That's because the underlying act was about payment of compensation. Those, yes, we have cases, but just per se from this kind of orders, can you get damages from the government? A big question mark. The Court of Judicature Act doesn't prevent us from asking for such remedy, but as far as my research goes, it's never been granted. And the UK totally blocks it, the UK law, okay? So that would be where we stand in terms of private sector with public sector domain. And I'm out of my 2 minutes. I haven't gone to my private sector. If I can beg the indulgence of our moderator for another 2-3 minutes, if that's possible. You're muted, Azrani.
Yeah, please go ahead.
Okay, so sorry for eating into that past my 10 minutes. Now, regarding the private sector, that means the question being asked is this: if you are the party that could not perform, you'll be worried. Am I still liable for my contractual obligation, which I could not perform during the MCO period? If you are the party on the other side, where you expected something to be done and it was not done, so you want to enforce the contract against the other party, the question you're asking yourself is, do I have a right to enforce that clause, that contractual obligation on that party that didn't perform, on the facts that that party is saying he could not perform because of the MCO? These are, of course, the two questions depending on which side of the fence you're sitting on. For that question, the law is only in two aspects. Okay, one is, does your contract talk about it? Okay, and that's the first question. If your contract talks about that scenario, then we follow the contract, what we call a force majeure clause. If your contract is silent, then then contract law takes over, and that is under the doctrine of frustration. Okay, so law being law, very coldly analytical, and it's black or white, we have these consequences. I'm only talking about the MCO, right? I'm not talking about the recession arising from the pandemic, which is what we're all going to face now in terms of a tsunami, okay? The legalities there is even harder to understand because recession is not normally given as a frustrating event. So I'm just talking about the MCO. You couldn't get into your shop, so you couldn't open your shop. Why are you asking me to pay rent, Mr. Landlord? Don't you have an obligation to make sure that my shop is able to be open anyway? These kind of questions come into play. So when you have a force majeure clause, then you follow it. If the force majeure clause says, during the time when parties could not perform due to that event, sometimes we call it act of God, sometimes we call it human events like riots and pandemics, then you follow the contract. Usually the contract says, for the time when you could not perform due to that force majeure event, parties are excused from performance. So the first person that asked the question, am I liable? The answer is no, you're not, because you're using a force majeure clause. The other party, can I enforce that thing on him? Answer is no, you can't, because he is protected by the force majeure clause. But of course, when that temporary force majeure event is ended, then obligations start again. Okay, you must resume your obligations under the contract. Now, what happens when you don't have a force majeure clause? This is where the problem is. When you don't have a force majeure clause, the law of frustration comes in. And the law of frustration says nothing about temporary inconvenience, temporary disability to perform the contract. The law of frustration says nothing about it. What the law of frustration says is when a contract cannot be performed or is unlawful, then the contract is terminated or becomes void. Section 57 of the Contracts Act. So it's either black or white. Okay? And the problem here is, in order to show that it's impossible to perform, you must show that the contract has become radically different. This has been affirmed time and again by the Court of Appeal and the Federal Court in the Malaysian courts. You must show that the contract has become radically different. That's why it can't be performed anymore, arising from that MCO of 3 months. There are very few contracts that you can say it's no longer capable of performing because we were locked down for 3 months. Very few contracts. So in essence, under the law of frustration, you do not have the ability to say, please don't hold me liable. Please don't hold me liable during the 3 months period. If I can't supply these goods to you, if I can't pay you rental in that 3 months, please don't hold me liable. But your supply contract is 2 years. Your tenancy is 3 years. It was only 3 months. The contract did not become radically different. So technically, theoretically, the landlord can still claim against you for the 3 months rental. The buyer of your goods can still say, you did not supply the goods during that 3 months period as per the supply contract. This is the legal situation we are in. Seems unfair. Okay, I repeat, if you had a force majeure clause, this would have been settled via the force majeure clause. So I'm talking about contracts without a force majeure clause. This seems unfair. And this is where I exit stage right and bring in Mr. Tay for, did we need an act to take care of this particular apparently unfair scenario? At this juncture, I'll take my leave. Thank you, Azrani.
Thanks, Paikat. I think we'll come back to you after this. I think there are definitely some questions that we want to cover. At this point, I'd like to bring in Mr. Tay. And I think Paikat has set it up nicely because, you know, from where we have and the current legal positions and the issues that come with that, we now go into the other frameworks. And bear in mind, Mr. Tay, one of the things that we probably want to focus on is looking at, you know, the outside world, how the others are dealing with this, how they have dealt with it, and, you know, looking at your expertise and your presence also in Singapore, where I think, you know, they've passed an act and there's some level of certainty there, and then or beyond that, and also then seeing what, you know, what kind of elements we probably need to have in our act, where the Prime Minister has already said that, you know, come July, when and, you know, to some people, if we have a Parliament sitting, we will probably have a COVID Act in place. I think I'll hand it over to you. And let's see how it goes.
Right. Thank you, Azrani. Very pleased to be here. Yeah, just taking over from Paikat. If you do have a force majeure clause, which is a precision clause for it to apply, and obviously you go under that. If you have frustration in your contract, you also don't have a problem. But these two are very problematic legal clauses, and they don't always apply. Now, we therefore need legislative intervention, and that has been done in many countries to varying degrees. People might ask, why wouldn't we use the Prevention and Control of Infectious Diseases Act to provide for these issues relating to business and finance? The short answer is that this particular act is not designed for that. So it is really clumsy. It has to do with health, prevention and control of disease has nothing to do with business. So you need a new piece of legislation to do the job properly. Now, currently, if I could characterize where we are in terms of the COVID-19, is that there is economic devastation. If you look at it like a patient coming into an emergency room of a hospital, the patient is injured and is bleeding badly, right? So the first thing you need to do is to stanch that bleeding, right? You have to stanch bleeding, and then you have to provide blood transfusion. Now, the blood transfusion is easy to understand. It's what our Prime Minister has been offering, budget stimulus. So that is your blood transfusion to avoid the patient dying. But in the meantime, you cannot effectively actually stanch the bleeding unless you intervene a bit more. Otherwise, there'll be complications like infections, etc. Now, this is where an act will come in. Over the world, in the UK, for example, they have a Coronavirus Act 2020. It does a lot of things, and one of the things it does, which we will not cover here, is that in UK you have a temporary register of health workers, of nurses, of volunteers, in social workers, and they get volunteer pay, volunteer leave, and so on. So a Coronavirus Act could be very flexible. It could do a number of things. Canada's own act, COVID-19 Emergency Responses Act, New Zealand too. But an interesting one for a Chamber of Commerce like MICCI is the Singapore Act. Now I say this because the Singapore Act has adopted a very interventionist approach in helping business survive this devastation. The Malaysian government, I understand from reading and from chamber materials, a bit reluctant to actually intervene in private contracts. The view is that private contracts is sacrosanct. But the view held by other governments who have sought to intervene is that we are talking about not ordinary times. This is not normal. That's economic devastation. And in economic devastation, you cannot talk about contracts. You got to go beyond that. You got to go to equity and what is fair. And of course, the wider agenda is that you do want a lot of your SMEs and smaller businesses to survive because they provide employment for the bulk of Malaysians. Now, if the SMEs do not survive, if our workers are unemployed, there'll be no demand in the economy. It'll take a much, much longer time to come around. And in fact, the courts will be jammed with litigation, petty litigation. That's not going to do anybody any good. So a piece of legislation like the COVID-19 Temporary Measures Act that intervenes in private contract in a measured way could be very useful. And that's what we will spend the next 10 minutes or so talking about now. Now, in Singapore, one of the main features of this act is that it provides temporary relief for inability to perform contracts. It's not any contract. Once you fall in the schedule of contracts, and I'll come to that in a minute, there is a relief. And what is that relief? I'll talk a bit about that. So the contracts that are likely to require help is actually like a secured loan financing. So if you've got a shop lot, a business loan, and you have pledged your plant equipment or your factory or your machinery or your commercial vehicles, you wouldn't want the bank to come and take it back. Because what we are talking about is, look, I've got cash flow problems, but I'm a viable business. I just need some time. Closing me down is no good. So the first category is a secured loan facility. Second one related to that, bill of performance bonds. Guarantees are given that could be easily caught, and probably the first thing people will call for people who are in breach is your performance guarantees. The other category is hire purchase and leasing agreements of commercial chattels, plant, equipment, motor cars. There's another category called events, contracts, and tourism related contracts. You have put in a deposit for a wedding, a big business convention, or inbound, outbound travels. Then there is construction and supplier contracts. There are leases and licenses relating to shops, commercial properties, factories, any real estate except except residential. And then there is also an option by housing developers and sale and purchase agreements between housing developers and buyers. So those are the categories, at least that's what Singapore has. And it's not a closed category. The minister can expand it. But these are the categories deemed to be in need of help the most. So if you are on the end where you are going to be in breach because of cash flow, because your shop cannot be open, you would tell your landlord, look, we need to talk. And if the landlord doesn't want to talk, he now realizes that there is a framework agreement in place which will force his hand. Because in Malaysia now, since there's no such agreement, you get sued by the landlord. Landlord will terminate your contract, kick you out of your shop, and that's the end of it. But with a framework agreement like that, the landlord knows he's got to talk and be reasonable. Because the moment you don't want to talk, the shopkeeper is going to send a notification for relief. And what that does is that it immediately stops you from suing me in court or to start arbitration proceedings. It also stops you from enforcing security. Let's say you got a charge over, a floating charge over my factory, immovable property. You will not be able to seize them. You cannot apply for bankruptcy and winding up applications in court. You cannot appoint a receiver and manager. You cannot execute a distress, a writ of seizure and sale in court against my property if you already had a judgment. You could not, as a hire purchase company, repossess my chattels, hire purchase leasing contracts. You could not terminate my leases and my licenses of non-residential property. And you could not enforce a call upon security guarantees or bonds. So you know that if you do not negotiate, you cannot take action, whether in court or extrajudicial by seizing assets and kicking them out of the shop. You cannot do any of that. So you're forced to negotiate. Now, if you still cannot come to terms, like for example, restructure the payment terms, offer some deferment, perhaps rentals are deferred and discounted, payment starts in November with a low interest. So these are the typical kind of arrangements that are made. But if you're not going to be agreeable to that and you continue to want to enforce your legal rights, it would be an offense. So that means the landlord in this particular case will be committing an offense if he disregard all this and pursues legal action. Now, it's important to say that this provides
Can you unmute?
Sorry, I think I was unmute. Yeah. How much did you miss?
A bit.
Can you hear me?
You could repeat that. Yeah, we can hear you.
All right. Now,
Yeah.
I was saying that this intervention to the legal contracts will provide such a thing called moratorium nationwide, but it doesn't alter contracts. It actually suspends and freezes it for a period of time, and it's stated to be 6 months. Of course, the minister could actually increase it longer to 12 months if necessary. So what happens is that the landlord and tenant, again in that example, will come together and they cannot decide. Then the landlord will be frantic, right? Because you're not paying me rent, and yet I can't go to court. I can't evict you. So landlord will call on a panel of assessors. Assessors are adjudicators. So there is a panel of assessors. You could write to the authority and they'll appoint somebody. And the assessor's objective is not to dispense, it's not to make an award or judgment based on law. The assessor's objective is to have an outcome that is based on fairness and equity. So you will look at financial wherewithals of the party and then adjust payment terms accordingly. Now, the thing is, depending on which side you are on, the beautiful thing or the terrible thing is that his award is going to be final. You cannot appeal against that award to the High Court or anywhere. And if you disregard that award, again, this is an offense. Now, what all this does is that because there's such a framework in place, business will be very careful. They do not want to accelerate this to the courts because they know they cannot go to the court. Now, if you do not have this framework law in place, what will happen is that a lot of people end up fighting when they are just about to recover. The economy is getting back, everybody should be working hard, but what happens is that people are starting to fight. So essentially, that is the main part of the Singapore Act. There are other aspects of it. If you can give me 2 more minutes, I'll just cover 1 or 2 more aspects. Charles, Rani.
Yes, please proceed.
Yeah. There is one section for relief of financially distressed individuals, firms, and businesses. Now, in Malaysia, we have done that. The companies exemption orders, a series of them have actually lifted the threshold from 10,000 to 50,000 before you can file an application to wind up a company, issue the statutory notice that you're unable to pay your debts over 21 days. They have changed that to 6 months. But what is missing in all this is the concept of fraudulent trading. The Act also takes care of fraudulent trading, and for lawyers who are in the call, you would know that this concerns a lot of officers and directors of company, because technically, when you incur credit or you buy goods and you have no expectations that they will be paid under present circumstances, it's likely they'll not be paid. The creditor may not go after the company because the company got no money. The creditor will go after the director. And I think this is a big loophole that is still not being talked about. If you got no expectations of being able to pay your debt, why are you incurring more debt? Why are you ordering goods to produce so that you can cook in your restaurant? Why are you doing that? You're losing money. Now you need that to plug that insolvent trading. Perhaps insolvent trading is such a substantial legal concept. The company's exemption orders haven't dealt with it, but you need an act of parliament to do it. And of course, when I say all this, it requires an act of parliament. So hopefully by July, that will be tabled. Okay, over to you, Asrani.
Okay, thanks, Mr. Tay. I think we got some questions coming in already, but straight off the bat, and I think this may be a question to ask both of you. You mentioned specifically just now about the concept of interventionist versus non-interventionist approach, and that's referring to the Act in particular. But this is a tricky one because I think we saw a pretty high level of interventionist approach when we went into the first round of the MCO, and in particular when we looked at from a business perspective, this whole idea of having an essential services list versus a non-essential, and whether that applied to only certain sectors and all. There was a pretty high level of interventionism there. But when it comes to the Act, you mentioned just now, Mr. Tay, that we need some level of intervention. My question to maybe Paikiat first to answer that, do you feel that that level of intervention that went in, particularly with the invocation of the the MCO regulations and the way it was done, was it done in a right way, or what could have been better? Certainly from our perspective in businesses, we were quite concerned over this whole list of what was allowable and not allowable, and there was a lot of high level of uncertainty who fell into what and all, and there were some parties who were by extension trying to be part of the essential services, so to speak. Was that the right approach, or could it be done better on that part?
Thanks, Asrani. So here I'm speaking, I guess, as a citizen, and not so much what was legally proper. I would think that the fact that we had a lockdown would mean that many businesses should not open, because it will lead to the spread of the disease, obviously, when you have free flow. And okay, so the fact that businesses had to be shut down is, I think, a given. Otherwise, why do you have this lockdown at all? So we're not questioning the need for the lockdown. So now, as you said before, it's like the devil is in the details. So now we say, but certain things need to carry on, otherwise people can't live. So we then bring down to essential services. And then essential services have to be defined, and we can always question why is the list too long or why is the list too short. And then the second kind of query is, you put the word food and beverage. What qualifies for food and beverage? What kind of drink? I saw you drinking a Coke, Azrani. So one, so one could argue, and I drink Coke myself, so I have nothing wrong with Coca-Cola. But it's like, hey, you know, is that really food, or is that healthy food or not healthy food? So it becomes that kind of question. And I guess the problem was, how do you call yourself if you are a casual provider? The items you give is casual in the sense that it's not needed to survive, biologically speaking. Why would you call it essential? So there's a mix-up between the word essential. Is all food and beverage essential? By being a food or beverage, you're already essential? Or do I have to go one step further and say, are you an essential food and beverage? So I think that's where the confusion was. And I would think that it would have been quite difficult to begin to divide up that, or having that kind of classification. Did MICCI do a good job when they made those decisions? I think there was some inconsistency, just personally speaking. And I think there was also some political underpinning that was going on here and there to allay the concerns of certain sectors of the public. And I think those could argue in court, I mean, just being legal now, those were irrelevant considerations, right? And it should be not based on those kind of considerations. And so if today this happened and it was still ongoing and you went to court and said, how come this is not essential, this is essential? The court could be with you in terms of, I agree with you, you should be classified back into essential. I think the court could agree with you because you cannot say that there's absolute discretion with the minister. I'll pause here, Azrani.
Sure.
Yeah.
Mr. Tate, maybe, you know,
I can,
yeah.
Could I add to that?
Yeah.
Yeah, I was going to just add that I think the use of essential services itself may not be the most strategic way of approaching it. You do need essential services as a classification of what can and cannot be done. However, in you cast your eye on the economy of the country, there are essential, critical economic sectors that should not be avoided. Economic sectors that makes money, exports, electronics and electrical, pharmaceutical. You know, some of these do not fall within strictly essential, electrical, electronics, but they are great export revenue earner. And if the government were to stop that, the economy will get worse. You're losing so much money every month. So I think they should have, in hindsight, expanded it to critical economic sectors as well.
Yeah, sorry, we lost you there. You mentioned something at the end there, Mr. Tate.
Yeah, I thought in hindsight, they should have included critical economic sectors. Yeah. Sectors that are important from the economic standpoint, export, revenue generators.
All right. Yeah, so I think, you know, it does raise the next question on this in terms of the link between the legal provisions and the policy intent that was, and somewhere in between the translation. On top of that, the implementation, in particular on the ground, where even the issues with regards to free, or movement controls, businesses had workers who were going from one area to another, but stopped by roadblocks, and were not able to go to their workplace, and then unable to then fulfill their obligations to the employers. Do you, in your areas, I'm sure you have your clients and all would have raised some concerns, issues, grouses, etc. Do you see that as a concern moving forward? Because when it comes to having a COVID Act later, and certainly as businesses, we absolutely want certainty. We want to know, what is the issue, and we want to know what would be the relief available to us, and so we can plan moving forward. But MCO just accelerated or enhanced or amplified the issues that came where between the policy and the legal provisions and the implementation, we were in sixes and sevens. We were not really sure, because on one hand you would have those daily press conferences which would say maybe this is what's going to come, this is what you can do, this is what you can't do. And then when you go into the specific regulations and the provisions, when going into the devil, the details, it's something else. And then when you go to the implementation, is another. I think the part where we saw, allowing for it, correct me if I'm wrong, but it's something to do with when we went into MCO 4, 5, where it was mentioned that interstate travel for work clearly was mentioned it was allowed, but then a lot of people were having problems still, and even if you showed the regulations and the specific provisions in there, things wouldn't have been really better depending on implementation on the ground. Do you see this as a concern moving forward, despite the fact that we may have certainty in legal words in an act? Mr. Tay?
Yeah, I guess there's a lot of learning on the job that's going on. I think there was SARS that a few countries experienced many years back. Can you hear me?
Yes.
Okay, so countries like Taiwan and a few others like Singapore would have experienced that and are far better prepared, perhaps. But to add to your point, Azrani, I think in Malaysia, the way you've done it is that we have a series of regulations, and they've gotten better. The government gotten better over time. For example, today is the 10th of June. We are into the RCMO, and the regulation number 7 pursuant to the Infectious Diseases Act is already out. And if you look at regulation number 7 compared to number 6, you find that the changes between CMCO and RCMO are actually reflected in that. Now, albeit, I must say that the drafting is very wide and general. For example, a lot of the things that you mentioned falls under a particular clause that says the Director General can give directions. And those directions can be how you do social distancing. It can be how you do workplace safety management. It could be anything. So all the SOPs that you see for manufacturing, even for the legal fraternity, we have our SOPs. You wonder where they came from. They came through that general clause. A Director General can issue directions. Now, so the directions of the SOP that's issued out sometimes through MICCI and sometimes to other agencies, those emanates from that. So I wouldn't actually fault the process because it's a fluid thing. It happens quite fast.
But wouldn't it be the case that I mean, it's an interesting point you raised, the fact that the direction of the Director General is there in the regulations. The thing is, there's still a misunderstanding perhaps between SOPs. Is that an SOP? Is whatever the Director General is saying, then, or is the SOPs coming from the Director General? I mean, these are the things that we're not aware of.
Okay, I can understand the apprehension. Is this an SOP pursuant to the Director General's direction? And we do not know. Of course, another way of doing it will be come up with a regulation that is very detailed as early as possible. So just citing the Singapore experience again, they have a COVID control regulations. And one of the first clause you see there is baseline restrictions. It actually says, everybody who steps out of your house must wear a mask. Now, as basic as that, from basic principles down, 1, 2, 3, 4, 5, 6, Well, of course, they keep improving on that regulation. But the point really is when you got a baseline regulation, you got a regulation that sets out all the SOPs, then people can look at that document and say with certainty, oh, that's the law. When you provide SOPs like that, it feels that it's not the law. And then a lot of companies will be ambivalent. Should I follow or should I not? When you talk about SOPs, normally they are not law, they are guidance, right? Standard operating procedures don't seem to be like a piece of legislation to me, if you ask me.
Sure.
But essentially, it sort of traces back to the Director General's directions.
So the trick question to both of you, one of you can answer this. If I don't follow the SOP, what's the penalty to me?
Not a trick question, quite easy, I think. I can go ahead.
Thank you, Mr. Tay. Okay, I think for me, it's a Malaysian style. So I had SOPs for my office using the SOPs given by MKN for Firma Guaman. And it said that you must sanitize the place every day at the end of the day and do it. It's an SOP issued. Now, I totally agree with the question mark. If I don't follow the SOP, have I committed an offense under the PCDA? Okay, and that could be a very interesting question mark in terms of being charged in court for not complying with an SOP, which is dubious as to whether it actually came from the DG or not. Okay, but Malaysian style, no one's going to use that. Okay, no one's going to use that. So what happens is, if I didn't do that, follow the SOP, and no one's the wiser because nothing happened, maybe we'll never be found out. Okay, but if we are found out and MOH comes in and says, you didn't do this, so now I hold you to be in a dangerous a dangerous entity, you might create a cluster because you didn't follow the SOP. It's not that I'm going to charge you for a dubious offense for not following SOP. What I'll do is I'll just declare your office an EMCO. And then shut down your office and say, I want to see cleaning. And I'm using the other powers that I have, which no one is going to question. If the DG says you are now a dangerous place because you may create a cluster because you didn't follow the SOP, I now declare you are red zone. Example, your office is a red zone. Everybody locked down for 2 weeks. I want to bring the professional, the deep cleaning, etc. And your office will not be habitable for 2 weeks. This is obvious Malaysian style, right? No one is trying to find whether you committed an offense. I just do the other thing that no one's going to question and no one can question anyway. So
but would that need to be gazetted though? That therefore your area needs to be then gazetted as a red zone, and then it goes through the proper process of the law. Then you will be at red zone.
Yes, but the power in the PCDA is also that would be a whole geographical area, right? But if I hold a particular premises as being dangerous,
yes,
they can do it straight away. Okay. You don't have to wait for the gazette. Yeah.
Okay. Which comes to the next point I have on this, in terms of the players involved in this. As businesses, and throughout that period of 4, 5, 6 weeks that we went through under the ambit of the PCDA and also the regulations, we had many authorities playing a role. And in this case, on the ground in particular, certainly police were there doing the roadblocks, and obviously they have general powers, on implement enforcement. But there were other things like local authorities that were coming in, ordering premises to close, or also then trying to play that role where what PICAT was saying just now, I'm ordering you, you're not following the SOPs, blah, 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 and then therefore. Now, isn't that, the question I have is that it felt a bit haphazard. It was very tiring for business owners because we didn't know who was going to be coming or enforcing, and whether they actually had the right powers to do so. So number one is, if say a local authority came in and basically said, you're not essential, you don't have the letters, shut down. In the first place, those letters come from MICCI. And of course, there's a question mark. Does MICCI have the right to actually issue those letters in the first place, and is that legal? Because this comes back to procedure. Who actually does have the ultimate right to actually enforce the procedure? That's number one. Number two is, doesn't that then, if it's a real confusion and we're still under the procedure, if we're looking at it at the moment, as we go into the COVID Act, isn't that one part that then needs to be then clarified and widened and whatever? And who has the general enforcement powers, particularly under the COVID-19 Temporary Measures Act 2020 in Singapore? So maybe I'll start with Paikat a bit on the first part.
Yeah, so again, I have to make some assumptions. It's just that I see, as I mentioned just now in section 5 of the PCDA, we all recognize that the principal government body having the powers under PCDA is the Minister of Health and the DG under him. So obviously everything must originate from the PCDA, okay? And based on those two high-level public officers. Then I mentioned just now, section 5, that they could make use of any other governmental agency and department to enforce what they had directed and instructed. So the backdrop, therefore, is there probably is such power. Now, whether it was probably delegated, did they have a town hall meeting with all the local authorities to say, okay, I don't have enough manpower, can you please do this via your local municipal officers and do this for me? Take this SOP or take these rules, take these guidelines and go from shop to shop and do the necessary to enforce this. Now, did that meeting happen? Or was it suka-suka? The MPPJ said, I want to just do this because I think I want to be a good public authority to just follow what I saw on the TV. I think that's unlikely. I think there must have been some kind of communication that, okay, guys, you have a bahagian penguat kuasa also. You have an enforcement person as well. Help me do this because you have all the record in your business premise license and you can go from shop and you know who is the business premise owner because they all applied for license from you. Please do this for me. So if that was done properly, then they're using section 5. And that's why I'm saying it's hard to challenge. And I'm sure it could have been done better. I'm sure the lack of coordination causes a lot of problems. And we hope that if it has to come again, it'll be done better. But maybe at this juncture, I would just want to underscore, this is the power of the COVID Act, actually, in Singapore. It was an omnibus act that spoke to every area of law or every area of administration that would be affected by COVID. Okay, whereas PCDA is a health-based. So you saw this, I'm sure, right? Where the DG, as much as he's our hero, he's our Superman, but he'll be saying health and safety come first. If I had my way, all factories would be shut down for 3 months. Then I could I could have the circuit breaker and you will not have any clusters after 3 months. Okay, and so he'll be speaking. Then after that, the voice came from the other side saying, as what Mr. Tay said, if you do that, Malaysia GDP will go down by 10%, in the next 3 months. You can't just do that. Can we do it in a balancing manner, in a balanced manner? Then you found that being the voice, the pushback coming from that side, which then caused DG to say, I understand now. It is between life and livelihood. I'm a medical man. I only care about life. What's the point of having life? What's the point of having no life to enjoy any livelihood? Then he began to see the balance, right? Now the COVID Act, the power of the COVID Act is it brings everybody to the table, right? We were doing piecemeal. The CCM, the Companies Commission said, okay, we will postpone AGMs. Okay, we will change the law on bankruptcy and winding up and the thresholds for winding up. Okay, we'll do this and we'll do that. Even the fraudulent trading was under this, and I'm glad to see that it's coming out now in Malaysian side. The fraudulent trading is being handled by the CCM, issuing the amendment. So it's happening. But it was done in that legislation. Whereas if you look at the COVID Act in Singapore, the Act amends the Companies Act. You see what I mean? The COVID Act amends the Companies Act of Singapore, as opposed to the Companies Act of Malaysia is amended to deal with COVID, right? And then later when COVID is over, you have to amend back that amendment. Right. Whereas using the power of the Singapore Act, it says for the time being, this section of the Companies Act is suspended and replaced with the following. So that when the COVID Act is repealed later because it's over, the old provision just automatically comes into play. Now, why would I do that? Oh, because I have CCM reps, the Minister of Domestic Trade having power over the Companies Commission, sitting at a table discussing how should we do this COVID Act. So that is actually the power of the Act, which to me would help in your issue, Azrani, about coordination between the agencies.
Mr. Tay.
Just to add to that, Azrani, just to add to that, I think since you're talking about a COVID Act in Singapore and in an Omnibus Act, the enforcement is actually done by different ministries. So it actually says that Section 1 to 10, for example, will be administered and enforced by the Ministry of Health. Section 11 to 20, for example, will be administered by the Minister of Finance. And the rest of the sections are administered by the Minister of Law. So you are actually delegating it directly to the responsible minister. It's not a Minister of Health trying to be a Minister of Finance as well.
Right. Yeah, and that provides the clarity on who's doing what, and we know who has the powers to do these things. So let's go to some questions that we have now. I think there's a different parts to some questions and the comments. Some will be a bit more operational. So maybe we'll take one first. I think Dato' Chris, who was our ex-MICCI General Committee member, so he asked here, he said, so it is an understanding between landlord and tenant to make use of the government's offer for special deduction and rental waiver, correct? So is that a yes, no answer, I guess?
Yeah.
Yes, again.
Yeah, it's correct. Yeah. Oh, sorry.
Go ahead. Yeah, I think so. I can relate an incident that happened in Singapore where landlords were not passing on some rebates and remissions to their tenants. For example, the government gave remission on property tax, and probably property tax in Singapore is quite high. They are supposed to pass it to the tenants. They did not. So they actually had a section in the COVID Act to say that if you do not pass it to your tenant, that is an offense.
All right. Okay.
Malaysian Star, on Chris's point, Malaysian Star was, I would say, rather clever, not as direct as thou have committed an offense by not passing down the government subsidy. What it did here was using the tax law, right, to say that if a landlord grants a rental waiver or discount, that amount that is discounted or waived can be used as a deduction when you file your income tax returns and thereby reduce your tax. Okay. So that's how it was done here. Provided that it is a tenant who is an SME. SME as defined by IRB for this particular special tax incentive.
Okay.
So that's how it was done. But now back to Chris's question. The landlord is having this possible tax break if he gives that rental discount. Okay. The law doesn't say he must give the rental discount. Okay. So the law is making you think about whether you would want to do it because it becomes a win-win. Whereas if there was no tax break, me giving the discount is merely a win for the tenant.
Right.
Nothing stops you from being compassionate, of course. Right? Nothing stops you from being compassionate. But there's no win-win. Now with this, there is a commercial reason to be kind to the tenant because you get a benefit by way of tax. Now, whether when you do the calculation, you will actually get the tax benefit, your tax guys have to do the calculation. But the point I'm answering Chris is, yes, it's not automatic that because this tax break was given, the landlord has to give that rental waiver. Okay, so there will be a need. So the question from Chris is, there needs both landlord and tenant needs to come to an understanding as to whether he would give a rental discount or waiver, how much that would be, and then the landlord can take that decision to get the tax break and weigh that before he agrees to that amendment to the tenancy agreement, that temporary amendment to the tenancy agreement. So you cannot avoid the step of amending the tenancy agreement to have that rental waiver or discount.
So it effectively means it's much more convoluted process in the case of Malaysia, because you're doing a carrot and stick approach in terms of trying to get the. Whereas in the Singapore interventionist model, and this is, I guess, something that really needs to be considered by the government, because we're trying to get the benefit down to whom? One. Number two, is the benefit being passed to the right parties, and it's trickling down, because at the end of the day, we're looking at the whole total economic system in any way. And in this convoluted system, you need those amendments and the negotiations with the parties, etc. Wouldn't we? I mean, would it then be better to have that part, because in the COVID Act, it's quite clear, and the Singapore COVID Act, it's quite clear that any property owners getting these benefits or rebates or whatever needs to actually pass this down to the tenant. Mr. Tay.
Yeah. Yeah, because I think the difference is that they are actually getting a benefit. The government has committed to say that we will not charge you property tax for this year. And if you keep it, it's a windfall. So the act makes it an offense if you do not pass it on.
Okay. Now, I think related to that, we have our friend Freddie, who's also on the GenCo. He basically asked this specific question. So even if the MCO, CMCO, RMCO, where a retailer tenant is able to open shop, it is reasonable to, is it reasonable? And that's the question. Is it reasonable for the tenant to ask for and landlord to give further rental reduction as the footfall into the mall is substantially reduced compared to prior to the pandemic? I'm not sure whether this is really a legal question or a commercial decision that needs to be made, but any comments or response from your side?
No. Okay, I think the realization Can you hear me?
I think you have to repeat.
That's running. Hello?
Yeah, you're breaking up a bit. Try again.
Okay. Freddie Lee's comments. He said, can you hear me? That's running. Hello? Freddie, I'm responding to Freddie. Freddie, I'm responding to Freddie RCMO, which is a fact. So tenants find that they need an stimulus or package of assistance. I think it's happening everywhere. The governments are beginning to realize that the devastation is so big that the initial fiscal stimulus and assistance they provide are not enough. So taking the example includes 2 months, and the law requires, and this is just a bill yet, I think, the law requires the tenant to provide an additional 2 months of rent free, because it seems that whatever has been provided is not enough. So I think it's an evolving thing. Come up again with more assistance, with more legislative intervention if the situation does not improve. As in Fred suggestions that footfall are going to be very bad for a long time. That's running. Over to you.
Thanks. Yeah, you were breaking up a bit there, but yeah, it's fine. I think there's some few other questions here which are quite interesting. There's a comment here, Mr. To, who mentioned here that any data surveys and petition from members and proprietors to engage gently and advise succinctly to government on this draft law, which need to be gazetted ASAP to provide the necessary framework for businesses and industries, including workforce, society, and livelihoods to maneuver in. Without it, might be a sluggish growth scenario, etc. I think it's more of a comment. Certainly from a chamber perspective, we definitely are monitoring this definitely closely. We do have a good bunch of lawyers in our chamber who definitely would give views, and the opportunity when it arises, we would try to push that to the government. But it does raise some other issues and concern because of the need and speed for which we need the act in place. Whether there would be a full-fledged consultation process that would be put forward. And so far, we've only gotten a briefing coming from MICCI. We've gotten an outline of what they are looking at and what they are not looking at. But we don't have a full draft of the whole thing. And certainly, we as a chamber, it's one part that we continue to push to be able to be consulted and really look at the details of it. And it comes back to the point that we highlighted earlier, that when we have been gone through this whole process before, the devil is in the details. And what is in the details and what goes into the implementation is in the other part of it. So definitely looking at that point. Yeah, but Paikat, maybe you want to comment on that.
Yeah, when I saw the Singapore Act, I thought it was a good act in terms of being detailed. But what happens, as what Mr. Tay said, there is a schedule in the Act, the Singapore Act, which says which contracts are supposed to have the benefit of being suspended. And it is limited, as what Mr. Tay has said, to certain kinds of contracts only. So for example, it says loan documents, the banking part, yes. Then it says construction and supply contracts. But supply contracts, as defined, if I understood it correctly in the Singapore COVID Act, supply contracts only relates to supply for the construction industry, not for, say, food, beverage, and things like that. It's not a general supply contract that's getting the benefit of that act in terms of temporary relief, right? And for tenancy agreements, it says non-residential tenancy agreements. So therefore, only tenancy agreements for commercial purposes is getting the benefit of the act in terms of, like, you can suspend payment of rental. The act forces the landlord to allow a suspension of rental if the tenant can prove that my inability to pay the rent is due to the MCO, right? So it's there, but there's no such help to residential tenancy agreements. So a house landlord, a home landlord, can evict a house tenant because he's not being protected by the Singapore COVID Act. Okay, so I think the point there is the concept of a COVID Act, I think is good, and I find it very hard to speak against it. But we may have to talk about, in the Malaysian context, we need a longer list of scheduled contracts that will get the benefit of the temporary relief, right? So enlarging the meaning of supply contracts, enlarging the meaning of tenancy agreements, for example.
Right. Okay, that's interesting.
There's also
Go ahead, Mr. Tay. Yes.
Can I just clarify? There's also a timing thing, concept that we need to understand in relation to how this act will work. First of all, it doesn't apply to any contract of performance which is to be performed on or before February 1st, 2020. So it must be a contractual obligation to be performed after February 1st. And it must relate to a contract entered into before March, let me see, I think 25th or 2020. Now, if you enter into a contract, so it must be in April and expect this act to protect you, then that's not the case. Because in April, everybody knows there's a pandemic and you shouldn't be going on to buy a $10 million apartment anymore. All right, nobody's going to help you. So the contract must be entered into before a certain period of time, March 20 something. So to take part, because in April everybody knows there's pandemics, and right now you go and enter in a contract to buy a lot of goods and not being able to pay. This act is not going to be able to help you, because you should know that there's no reason why you should be doing that. Yeah, over to you, Sonny. Right now you go and enter in a contract to pay. This act is not going to be able to help you, because yeah, over to you.
Yeah, thanks. Okay, so again, it comes back to the level of having some certainty in that would impose a level of certainty to business operations and to our contractual obligations as well in this difficult period. There's a very interesting basic question. First of all, I thought it was just is it too straightforward a question? But I guess there are some legal implications here, and I think this is coming from Doreen. It's asking, if an employee is COVID-19 positive today, how does that affect business? And I guess in terms of operations as well, and we look at SOPs and all these other things. Will that particular business premises or whatever be forced to close? Now, I think I'll just extend to that. Does the government have the power to impose a closure?
Certainly, they have the power to impose the closure using the PCDA, and most certainly they will do so. But they will immediately do contact tracing, because that's the whole purpose of flattening the curve, right? And we're supposed to be down. So if you find a person who is COVID positive, the immediate concern of MOH would be to find the cluster,
right,
and then to contain the cluster. Hopefully not with barbed wire. Okay, so your office will be a cluster.
Yeah.
Now whether, for instance, my office has 2 floors, so whether we say only level 26 will be locked down, level 25 will not be. It depends on whether you can convince the MOH that employee in level 26 never went to level 25. I think it's going to be a tall order.
Right.
I'm not sure that the whole building will be locked down. That's a question mark. Yeah, but I certainly believe your premises will be under lockdown, issuing an order under PCDA. Yeah, based on the interview that MOH will have with that positive person, because there's an obligation to get that positive person in hospital, right? And through that interview, they will know that through the contact tracing, they will know who should be locked down.
Yeah. Did you feel that that's a bit draconian? Even if you have one person in there and you can have the isolation processes in place, that to just basically shut down the whole business and impact operations altogether, because some places you do need to continue that operations, and this is where I think anything worse than stopping businesses is to start and then stop again. And the stop process is probably even more damaging. Is that, I guess the question is that would be fair? Maybe I'll pass that to Mr. Tay. Do you think that
I think this is what contact tracing is all about, and cross-infection, and therefore I think it's a matter of health. If there is a chance of cross-infection by these people, the premises would have to be closed down. So strictly from a health perspective. So I don't think it's unfair. And that's why it is so important for businesses to stick to the SOP in their own self-interest, to make sure employees do not get sick. If your employees are not taken care of and sick, it means your business will have to close.
Yeah, which then there's the other question that's come through from Wanda, and it's asking that as part of the SOP, all employers are required to get their employees to download this app, and this app and few other apps that's around there, and this issue of app of data protection and all these other things sometimes is creating a bit of concern among the public of whether we should be downloading some of these things. Certainly that's part of the SOPs for businesses. But the question is, how can employers ensure compliance, and what is the legal liability if we don't get our employees to comply?
I need help here. I'm not sure what this app does. Do you know, Azrani?
To be honest,
Contact tracing.
yeah, I think the MICCI app, among a few other apps that are out there, it's part of the contact tracing process. So I believe it's part of the SOPs that are encouraging, and again, this question about encouraging and requiring people to have the contract, the apps and all. But it comes back to the SOP. If certain parts of the SOPs are not followed, would that render businesses, having to deactivate?
Yeah. Well, it depends on whether the SOP is part of the directions issued by the Director General again.
Right. Okay. So
for example, yeah. So for example, entry, when you enter a premises, you're supposed to have that app in a QR code where you activate to say you've entered this premises.
Yeah.
And when you leave, you're supposed to register when you have left the premises. And those are actually legislated in some countries. You need to do that. So it comes back to the basic. Some countries don't legislate the wearing of a mask. Some countries say you must wear a mask. And I think in UK now they say if you are in a public transport, you must wear a mask. So they arrest you if you're not wearing a mask in a public transport.
Yeah, so I think, that's an interesting point you raised, Mr. Tay, because we saw yesterday some statements and in fact conflicting statements coming out from both the government and the operator of the public transport. And on one hand, it was highlighted that we should, there's no social distancing that will be required anymore on public transports. And then after that, it was the senior minister came out and said, no, you still need to have social distancing, so it hasn't been redacted. And I think MCO, the regulations which happened, I think has some clarity on that. But it boils down back to issues of definition as well. Some basic stuff where I guess, do we need, for example, a real clear definition of what is, say, social distancing, for example, because we see that thing coming out. It's basically mentioned recommendation, but if people don't follow, and we're now seeing quite a lot of situations where people are not following, they're just lining up very closely to each other. Is there a definition that needs to be put on, placed quite clearly, like putting the mask and all, like as you mentioned?
I venture to think that you have to look at the SOPs issued for your particular sector. So I think they are different from manufacturing, from a service, and for different industries. So essentially, the SOPs actually has guidelines about how you handle equipment, machinery, cleaning, social distancing, even canteen. I think at some point in time, if you have a factory, factory canteens were asked not to serve food, but to offer pre-packed food. But apparently, somewhere I read, they now can actually serve food, provided it's not a buffet line, provided you serve the food to the workers. So the whole thing is actually evolving all the time. And it depends on the SOPs. But I agree with you, the SOPs cannot keep up quickly enough with the changes on the ground. So it's causing a lot of confusion. So that I agree. That's a lot of confusion on the ground. So the best thing is if you can get a hotline to somebody in the ministry, that would be really helpful.
We have a question here, well, more as a question, I think, from Renuka, our friend Renuka, who I know had quite a lot of issues during the MCO, which we won't go into details of. But I think she's very interested in the Singapore legislation. I think we discussed that in quite a bit of detail. I guess when she mentioned about perspective, Mr. Tay, it's really we've gotten the legal perspective, which you have highlighted. how is businesses looking at that on the ground there, and that with the regulations, the level of compliance, any comments or issues that they raised in terms of what could be better, or as the government there covered all well?
Yeah, I think I guess we all know Singapore has got very high enforcement standards. So there are a number of prosecutions. There are as well in Malaysia. And when you do get some foreign workers flouting the rules, the first thing they do, apart from prosecuting you, is to revoke your work permit. And that sends a signal, a very strong signal to all employers. Because as you know, like in Malaysia, you need foreign workers in many industries. If your foreign workers get deported, you're not going to be able to operate your factory. So when you revoke your work permit because these workers have not been following the social distancing and the SOPs in the workplace, you effectively got a shutdown. So compliance level, I think, depends on enforcement, as in everywhere else. If you've got good rules and you don't enforce them, nothing happens.
Yeah. Well, as businesses, and many of us are operating pure, proper, compliant legal businesses, obviously the level of enforcement is something that we are definitely concerned about. It creates an unlevel playing field when you're operating legal businesses, but that there may be parties that are taking advantage of the gaps in property enforcement that allows for illegal businesses to thrive. So I think we all know of that, and we hope that will be moved on. I don't see any more questions coming through. I think we've covered quite a lot in terms of the issues around this. I think I'll just take a bit of time at the end to really ask the questions to both of you, and especially moving forward. First of all, your perspectives of what do you think and how do you think, more from the legal side, moving forward from now until, at least until the end of the year or so, what are the probably issues that may be cropping up, in the current status? And then secondly, then in the COVID Act, in the absence of the full draft that we're not seeing at the moment, what is your wish list and hope, taking into Malaysian context? Because I know, we discussed a bit about interventionists versus non-interventionists, and Paikat mentioned about we need to see to quote his own words, the Malaysian style, what we need. How do you see the construct of a COVID Act should look like for Malaysia? And I think that's something that maybe there's a bit of time we need to actually go, elaborate on. So maybe Mr. Tay, you can start first.
Yeah, I think it's so important to have a dialogue and consultation between the government and the businesses. So the chambers of commerce and all really need to work closely with the government, because the problems on the ground, I think, are never appreciated fully by those in the bureaucracy. So that is one thing we need to do. It's the worst thing that can happen, I think, is for them to pass an act, for the government to pass an act without consultation. But having said that, consultation cannot take forever as well. Yeah. So it's sometimes a work in progress. You need an act with sufficient details of what is needed, but with enough flexibility to be amended, or what you call control orders to be issued progressively in response to the evolving situation on the ground. So my hope is actually there's a high level of consultation, an act that is very well drafted, that takes into account business. Now, I think say business because essentially and hopefully we have the disease almost under control, but it's the business that's dying. So businesses' concerns are paramount.
Okay.
So I mentioned just now the rajan that for the COVID Act was directly on MCO type scenario. So it's I mean, God willing, and everybody plays their role, it will be, albeit a new normal, but we're back to business. Okay, almost BAU, business as usual. Okay, just make sure you wear the mask and you're not next to your colleague in office. Hopefully it lands there from a health perspective. So the COVID Act, in a sense, we are too late, but it can refer back to breaches of contracts during the MCO period. You get what I mean, right? The Singapore Act says for this 6 months period, which is when the MCO was happening in Singapore, the lockdown, for this period, this is what happens to contracts, liabilities in contracts and obligations in contracts. Okay, and if it was done early enough, it would guide people in their legal obligations then during the MCO. But now we are about to exit out. But it's okay to talk about, so please don't call it a breach. Please don't use that breach as a breach because it happened during the MCO period. So it's like speaking backwards, right? Yeah, and I'm okay with that. I'm okay with that. At least that's some kind of relief for the genuine victims of the MCO. So what we don't have, in fact, I'm also not sure, and I stand guided here by Mr. Tay. It just says that you suspend the enforcement of your legal rights, the contract. But it may mean that after the 6 months, I'll still sue you for the rental you didn't pay. It doesn't actually wipe out the rental that wasn't paid for the 6 months. But if you can prove to the assessor that I couldn't pay the rental because of COVID, then the landlord can't sue you during that 6 months period. But I guess after the 6 months, the landlord can sue you for 6 months rental, right? And if that's a tsunami about to come, if that's a tsunami about to come.
Yeah, you're right. I think, you're right. But 6 months is a good time for parties to come to some kind of agreement where the cash flow is stretched out and people can pay their obligations. But you're absolutely right. It doesn't change the contractual obligations. It just suspends it. Hopefully, be replaced by a new set of restructured contractual obligations. But of course, if the pandemic goes on and doesn't improve, the minister can extend it, perhaps to 12 months. All right, that buys you more time to get well. Yeah, so it is a panacea. It's not a panacea that is going to cure or excuse you from performing your obligations, because I think they'll be too drastic to excuse everybody from the contractual obligation forever. That's not going to be it.
Yeah. So for me, we need a sequel to the COVID Act, which is now, how do you deal with the recession? Right? So we're all back in office, all back in business, all back manufacturing, etc. Business as usual, but some never recovered, or some need a bit more help. Please don't sue me yet. Please don't sue me for 6 months areas of rental, assuming the restrictions are all off, right? Yeah. Then the COVID Act as is now no longer protects you from that 6 months rental payment. Right? And as much as I totally agree, Mr. Tay, where you have two parties that try to be reasonable with each other, yes, but nothing stops the landlord on the current COVID Act in Singapore from saying, okay, no worries, I won't go after you for the 6 months rental, but when the COVID Act is repealed because you no longer need its effects, please pay me 6 months rental. And it will be within his legal rights to ask that, and I just don't know how. In the days of our financial crisis, we had a Dana Harta Act, which helped to save some of the businesses, right? And so we may need some kind of help in that sense to a rescuing entity, right? To what happened in Dana Harta was, a government, a GLC, took over liabilities so that businesses could say, this liability has shifted to Dana Harta. So Mr. Landlord, you deal with Dana Harta, let them talk to you how this liability of 6 months rental is being dealt with. You talk to them, because by law, the liability for the 6 months rental has moved to Dana Harta. Okay, so we may be looking at that if we say this pandemic recession is worse than ever before, compared to all the previous financial crises. So that could be stage 2 of relief from COVID.
Yeah.
Yeah.
Because you mentioned about
So,
health there just now. So, and I think there is
sorry,
a question. Yes, sorry, Mr.
Sorry,
Tate.
Asrani, very quickly. I
Yeah.
think before we get to Dana Hata, that's where the fiscal stimulus comes in, monetary and fiscal. Governments are supposed to give soft loans to all these small businesses so that they can get enough money to settle and pay the landlords and to pay their obligations. Even in the US, the Federal Reserve is now looking at dishing out loans directly to small and medium enterprises, bypassing all the banks in US because they say the banks are too slow. So they may be lending directly to businesses. So businesses should go in and take a 500,000 loan just to help you pay off the landlord, stretch things over and hope to recover. So hopefully those stimulus comes in time now for you to be able to stave off bankruptcy. Yeah, over to you, Asrani.
Yeah, I think, the point that we heard just now, before you were interrupted, was that the stimulus needs to kick in fast. I think that's a position as well of MICCI where, it's very all good and well to have, the announcements on the support to businesses, individuals, etc., and these, measures that have been informed to the public. But at the same time, it's the implementation that is going to be key, and how fast the support goes into the system, then it impacts how the economy will be supported. When you mentioned about help, Paiket, there was also a question there, and this is an interesting one. I didn't really understand in the beginning, but I think it's interesting because everybody looks at it from different perspectives. Of course, if you're a multinational, you have the deep pockets, you can weather this, yes, you're impacted, but you may have different issues. Certainly, one of the issues that we are looking at is issues of SMEs. And there is a question which is I thought very interesting. I think, it's all good to have a COVID Act. I think this is coming from, Ida was mentioning here, but I think it's coming from the angle of listening to you guys and seeing that maybe there are legal issues, and as we go along, 5-6 months down the road, there'll be a lot of legal proceedings and people suing each other, etc., etc. The question she has is, do you think the Act should also cover maybe legal professional and services assistance to support businesses in sorting out these areas of them being challenged, etc.? Any views on that? This is maybe requesting for a handout within a
not exactly, Azrani. I think it's interesting, but I can tell you, if you ask the lawyers to get involved, you'll never be settled.
Okay.
So essentially, in the notification for relief in Singapore, lawyers or legal representations are not allowed. That's how you're going to settle the matter.
Right.
And the assessors are not judges. The assessors are professionals like lawyers, accountants, business consultants, management people, engineers, architects of the construction industry. They are appointed by the minister, and I think they might be paid some small emoluments for their services. So it's actually a very low cost way, instead of going to court and hiring lawyers to work for you. Use these assessors and they will just solve it in a much more expedited than the courts. And as I say, if you get lawyers involved, then I don't know, there's going to be legal fees, there's going to be court timeline and all kinds of complications. So better stay away.
Yeah, which comes to a question, I think, before we close off the session, it comes to really your areas. My question on that is, okay, first question is, do you foresee, with all these issues that have been, that have been discussed here today, that in the next 1 month or 6 months to a year, that we are going to see an upsurge in terms of, legal cases out there, i.e., do you see your operations being busy? And that's one. The other question is, everybody's talking about the new normal. I know Paika mentioned about SOPs and all. What is the new normal in your own profession? And how is that going to be moving forward? Any changes there? Paika first, maybe. The two questions. Yeah.
Yeah. We are already seeing an upsurge. I'm just talking about the legal industry. Yeah. An upsurge on the force majeure clauses issues and how to understand them. Then the question becomes how to enforce a contract in the light of either the doctrine of frustration I mentioned or the force majeure clause. But we are really seeing clients under financial stress. So whether or not lawyers have more work or more revenue generating work in the coming months, I think we're all bracing ourselves for a difficult time, because like any other, although we are a profession, like any other business, there will be these challenges. How many clients are still surviving in the midst of all this economic turmoil? But yeah, there will be an upsurge of that. I hope that also together with that will be an upsurge on restructuring contracts, as what Mr. Tay mentioned. Yeah, and we're hoping that will happen as well. So I'm hoping, and not just for the sake of the law firm, but helping the country recover and doing our part to do that. Yeah. So in terms of the actual legal practice itself, for the non-litigation side, it's almost has been business as usual. I still think that WFH, working from home, means working far harder because you're having to do the Zoom and then you're going back to office and so on. That's how I interpret WFH. But the litigation side has been really changing because of the courts adjusting to video conferencing to hear cases. And now, for instance, in our office, we have to create two virtual hearing rooms where the lawyers going to fight the case, they're actually in our meeting room fighting the case using audio visual and IT in order to fight the case before the court. And that's what the court wants as well. The court are like alternating how many cases they can have and trying to practice social distancing inside the courtroom.
Right.
You know arguments we've seen, right, where the lawyer says, I can't talk to my assistant 2 chairs away, he can't hear me, that kind of stuff. So that's already happening in the courtroom scene. We haven't a landing yet, but I think we'll soon get there. Thank you.
Sitay?
Yeah. For us, I think we're seeing a big uptick in employment law. People talking about retrenchment, layoffs, and whether or not changes are compatible with the employment practice of the company. So there's one area. The other area is aviation is at the forefront of what has been hit very hard by this pandemic. Now, of course, there's a lot of restructuring in the aircraft leasing and financing structures, deferments of payments. So that's very busy as well. And then the other one is very generic across all sectors. There's a lot of restructurings. And when you get certain types of restructurings, you're looking at competition law issues. So there is a concept in competition antitrust called crisis cartel. You might not be able to do certain things in good times because it's anti-competitive, but in a crisis cartel, the failing or falling firm defenses. So these are issues that come into place. Could you now have a bit more indulgent from competition commissions? So some commissions in the world have come up with policies. I don't think in Malaysia we've done that, but certainly there are a lot of companies that are restructuring and asking us, what do you think? Is this going to run foul of the competition laws in Malaysia? Then the other thing I would hope for the Malaysian government to do is to have a green lane and a fast lane for travel, essentially business travel. I think we are so plugged into a global economy that we don't allow businessmen and expatriates to come and work and ask them to be quarantined for 14 days. How are we going to recover? Look at North Asia. North Asia is out recovering. People are traveling, but we are still saying Malaysians cannot travel until 31st of August. Perhaps that might need some review, I think. Yeah, over to you.
Thanks, and I think you've touched on very pertinent points there. I think right now that issue of travel in and out is the next stage of some of the discussions and debates that needs to be had. Certainly from the chamber's perspective, it's one thing about doing business. The other thing is about having the physical movement allowed, and this comes back to the issue when we had recently with the MCO 1, 2, 3, and about the restriction of movements that then impacted businesses as well. So I think we've touched quite a bit. This has been, I hope, a very interesting session. I've certainly found it very interesting, your views and comments, which I hope would also be received and taken up by the government. Certainly, as I think Mr. Tay mentioned just now, debate and discussion, consultation is going to be key. It's the right time to have these discussions as we go into the part about seeing an act being developed for Malaysia. But certainly, well, as we go forward, this kind of forums and discussions should continue to be organized, and maybe we have more people to join in. But it is a fundamental issue and a fundamental topic about our legal rights and the legal fundamental basis of things that impacts our operations. So I really want to thank both of you for taking part in this. I just feel it would be short, and there may be a lot more other issues that could be touched on. Perhaps we can have another session later after we actually have an act, which we can then assess, where would be the little areas where it could be issues and what are the solutions that could be put forward. So on behalf of MICCI, to both of you, thank you on behalf and also to the people who have tuned in. Thank you very much. Sorry if we haven't been able to cover all the areas and your questions. But please do stay tuned for other things as we go along later. There'll be other issues, and obviously this is a series that we will be having to have these dialogues and discussions. So thank you very much. And if you have any questions or any feedback, do forward that to the MICCI Secretariat. Yeah.
Thank you, Azrani, and thank you, everyone. My apologies if the sound quality hasn't been perfect today.
No worries. Yeah, we live in an imperfect world at the moment, but we hope we continue to live in hope.
Okay, thank you.
Bye.
Thank you, everybody. Thank you.
Thank you. Thank you very much.
Thank you. Bye-bye.